started with today's hearing. Just a couple of things real quick for everyone. First of all, court proceedings by their very nature are very emotional. And I know it's very difficult sometimes for folks to keep their emotions in check while in the courtroom. But it's important that you do so to the best of your ability so that you do not disrupt the proceedings. I would imagine that this is going to be the first of many proceedings in this case. And because of the fact that it is receiving a fair amount of media attention, I've already signed what's called a decorum order. Ask all the media folks to please take a look at that order and abide by that order today and every hearing hereafter. Okay, if you do not request permission from the court to be able to record, videotape, take photographs, then you cannot do so in the courtroom while proceedings are going forward. Only those media folks that have received permission from the court can do so. If there is anyone taking photographs or videos improperly, I will ask the deputy to retrieve whatever device that they may have until after the proceedings and then decide what to do with it at that point in time. Also, as part of the court's decorum order that's in place, okay, I've indicated that there cannot be any types of signs, placards, t-shirts of any sort of support for any side or any party in these matters. I'm putting that order in place because ultimately at some point in time, it's likely that we're going to have to see a jury. And I do not want individuals in any way trying to, in any way, influence persons that may be selected as jurors in this case. This is probably the first of several decorum orders that this court will be issuing throughout the proceedings, depending on information that makes its way to the court that may require me to place further restrictions on the parties as we proceed. All right, this is case number 21 CR 451, State of Ohio versus Adam Coy. Counsel, if you please, give me your appearance for the record.
Thank you, Judge. Anthony Pearson on behalf of the State of Ohio.
Good morning, Your Honor. May it please the court, I am Mark Collins, 0061207.
Good morning, Your Honor. I am Caitlin Stevens, 0095589.
And we are co-counsel, Your Honor, for Mr. Coy, and we spoke with Mr. Coy. I spoke with him both Saturday and Sunday, Your Honor, and he's agreed to waive his appearance for today's proceeding.
Okay. Thank you. Okay, this matter is before the court today on the defendant's motion for the court to reconsider bond in this matter. So on behalf of Mr. Coy.
Thank you very much, Your Honor. May it please the court. And first and foremost, I want to thank the Assistant Attorney General as well as yourself and the court administrators for setting up today's hearing, Your Honor. I understand there's logistical aspects that are out of the normal, and we appreciate the professionalism and courtesy shown by everyone to us and to our client. Your Honor, as the court's aware, Ms. Stevens prepared and filed a motion for reconsideration that was filed on Sunday. I'm just going to highlight a couple areas, Your Honor, and talk about general concepts, and the court has any questions after that we would answer. Your Honor, in going backwards and trying to assess what occurred last Friday, I see it was kind of maybe remiss on me, Your Honor, and it happens in our criminal justice system a lot in terms of what was lost in the translation in terms of that hearing. And any time there's an indictment, Your Honor, where probable cause comes back, it's always put kind of in contradiction to an individual's presumption of innocence. And a presumption of innocence, Your Honor, as the Supreme Court of the United States has indicated, that this traditional right to freedom before conviction permits the unhampered preparation of a defense and serves to prevent the infliction of punishment prior to conviction. Unless the right to bail before trial is preserved, the presumption of innocence secured only after centuries of struggle would lose its meaning. So I think, Your Honor, we don't talk enough about the presumption of innocence at arraignments and at bond hearings. And here, there was probable cause found for a knowingly cause or attempt to cause serious physical injury, Your Honor, and which approximately would result in death. Not a purposeful, not a prior calc or anything of that nature. And so Criminal Rule 46, Your Honor, indicates that if you're going to take someone's freedom, you have to analyze the three components outlined in Criminal Rule 46. First being reasonably assure someone's appearance at court. The second one, Your Honor, whether or not the safety of an individual or potentially the community in general requires that person's detention. Your Honor, in addition, whether or not that potential person potentially could obstruct the criminal justice process. And I think what was left out on last Friday, Your Honor, is in Criminal Rule 46, it specifically states that the analysis should start with the premise of it has to be the least restrictive conditions. And those words are actually in Criminal Rule 46. And the reality and the effect of the $3 million bond that was set last Friday, Your Honor, kind of goes in the face of all the bond reforms that our state's working towards, the bond and bail reforms that the country's working towards, and I know this court is very active in that process. And the $3 million bond basically says if you're wealthy, you can get out. If you're of average means and poor, you're going to be in the court system until you have your trial and there's a verdict. And, Your Honor, we believe that the Ohio Supreme Court, Your Honor, is also addressed that aspect. And Justice Justice O'Connor here, I apologize, Your Honor, indicated, and it's in Ms. Stevens' motion, that it's very important in the state of Ohio to recognize the importance of equal justice. For it is up to our court system, the judges, and the lawyers to ensure that the constitutional guarantees are applied equally. She indicated, Your Honor, that undermining our constitutional guarantees is one of the most decimating practices we as judges use in the criminal matters. The setting of bail, a system by which defendants must pay for their freedom. She recognized the purpose of bail, Your Honor, is not to keep people in, but to allow the release pending the resolution of their case. The constitutional demands release without bond unless there's a proven risk, Your Honor, of flight or danger to the community, including victims, witnesses. The justice system all too frequently fails to uphold the just bail practices. If cash bail is required, Your Honor, the Supreme Court Chief Justice said it should be set in an amount the defendant actually has the ability to pay. When you look at the totality of the situation, Your Honor, and addressing the three concepts and factors, and I'll just walk through them briefly because they're addressed in our motion. First one, Your Honor, is whether or not the assurance of the individual for court appearance is whether or not a flight risk. Your Honor, our client has no record whatsoever, has no history of noncompliance. Our client, Your Honor, voluntarily went through a walkthrough at the scene on December 22nd with the BCI agents. He voluntarily presented a lengthy written statement, Your Honor. He then agreed to a voluntary interview, Your Honor, that lasted over 2 hours and 15 minutes. He has cooperated in all aspects with his attorneys, with the Columbus Division of Police when he was still employed there. He had requirements of what he had to do. In addition, Your Honor, when the Attorney General's office called and asked him to turn himself in, he voluntarily did that, Your Honor. So we don't believe he's a flight risk. Next, Your Honor, Criminal Rule 46 outlines the concepts number 2, safety of the community or an individual, and the potential obstruction of justice, and 3, should first be viewed through all relevant information. And it specifically states that in Criminal Rule 46, all relevant information. We believe, Your Honor, that it's relevant in any analysis on a fair bond or a reasonable bond, one that's not excessive and one that is not punitive, is that you look at similarly situated cases. Ms. Stevens and I have represented an individual and gone to trial on a police shooting in which the officer in Pike County was mistaken that the victim had a gun. A $100,000 bond was set in that case, Your Honor. In our court system right now before Judge Young, we represent Andy Mitchell, Your Honor, who has multiple felony charges, and in there $1 million bond was set. We researched and provided the court with national cases, Your Honor, for the most part are from $75,000 to $500,000 with police shootings, Your Honor, and use of force. The outliers are the $1 million cases. There's 2 of those, Your Honor. So we believe that that's relevant information that should go into the analysis of setting a reasonable bond. In addition, Your Honor, Ms. Stevens and I looked at our local cases. We have 12 pending murders right now in this court system, Your Honor. And of those, Ms. Stevens listed the 4 or 5 who are out on bond, Your Honor, of anywhere from $25,000 to $500,000. And the importance there, Your Honor, is those are purposeful murders. Those are with gun specifications. Those are with prior records. Those are for individuals who can't, who are charged with much more egregious things in terms of the purposeful nature or the prior calculation, Your Honor. And the ones listed by Ms. Stevens are the ones who are actually out on bond in our court system right now because a reasonable bond was put in place. We believe, Your Honor, that when you look at those, to ignore those, as we believe occurred, to ignore those makes the constitutional defenses put forth unjustly applied. And that's why we do believe that those are relevant. Specifically, Criminal Rule 46, then to analyze the second, third components, Your Honor, gives us factors to look at. The first factor to look at, Your Honor, the nature and circumstances of the offense and whether or not our client had access to a weapon. Your Honor, he was lawfully allowed to have a weapon, on-duty police officer. That's why there's no gun specification attached in this type of case, Your Honor, because it's a legal right for him to have a weapon. The nature and circumstances of the offense, Your Honor, and I'll include this with both, I apologize, he's placed into a situation where a split-second decision must be made on an on-duty situation. When you look at factor number 2, Your Honor, the evidence against defendant, there's a videotape, Your Honor, as well as some witness statements, and there's about another 2-minute interaction that will come out eventually at trial, Your Honor, or in the negotiations or motion hearings. So there is more to the story than just the video snippet in that situation, Your Honor. And again, because it's an on-duty shooting, because it's a law enforcement, as the court is aware, Graham v. Connor outlines the potential offenses that are afforded to our client because of that. And as the court is well aware, the actions, his subjective belief and his reaction has to be looked through the lens of a reasonable police officer. And we believe that when you look at that situation, Your Honor, that's basically the evidence against our client. Identity is not an issue, Your Honor. I can promise you that at the appropriate time, Ms. Stevens and I will stipulate to the identity of Mr. Coy and the fact that he was employed to become a police officer. And there is no dispute, Your Honor, that in fact our client took the life of the victim in this case while on duty in that situation. The only aspect, Your Honor, that will be analyzed for a potential trial is whether this subjective belief, reviewed objectively, was reasonable or not. And that's why these cases are unique to our court system and they're not here very often. And they ask for special treatment in terms of the analysis, Your Honor. In terms of, then goes to, Your Honor, in terms of family ties, number 4, Criminal 46, it gives a whole litany, a list of things that are there. Again, Your Honor, our client is 44, a lifelong resident of Central Ohio. He was born in Central Ohio, graduated from high school in Central Ohio. Then entered the military, Your Honor, where he served honorably for 5 years. He received an honorable discharge and it had the rank of sergeant. Came out, Your Honor, started at the Delaware County Sheriff's Office, moved to the Columbus Police Department. He has 3 children, Your Honor. He has many, many family ties in the Central Ohio. He has no mental health aspects. Your Honor, we make sure that he has no access to guns or anything of that nature. They've all been taken out of the equation, and I can assure the court if the court has any questions about that. So all of those, factors, Your Honor, come down in his favor with regards to factor number 5. Your Honor, again, this is a situation and we're asking for a reasonable bond. We believe a reasonable bond based on our experience and our dealings in this court system every day would be anywhere from $100,000 to $400,000, Your Honor. We believe in addition, Your Honor, and this is a specific request we understand why the magistrate put in place a stay away from any witnesses in the case, especially police witnesses. And we will abide by that 100% to stay away from the victim's family or anything of that nature. However, Your Honor, there was a blanket condition put forth in that they mandated that he must stay away from all police personnel. And I don't know if that was a typo or if it was a mistake or if that was the intent. But basically, Your Honor, for the past 19 years, our client's family and friends are all police officers, Your Honor. Those are his support systems. Those are the things that he deals with every day. In the situation, Your Honor, there's actually a division of Columbus police officers who are trained especially to reach out and communicate with our client on a daily basis to talk about things because those individuals were also involved in use of force things. So we would ask, Your Honor, any modification also include that he be allowed to have contact with Columbus police officers off duty and who are friends and family. Not specifically, Your Honor, we understand he cannot have any duty with police officers who are there that day, that evening, or associated with the case at 24/7. And again, Your Honor, we liken that to if someone in this courtroom was involved in a shooting, that would be like an order saying you can't talk to your family. We just don't think that individual purpose, Your Honor, or that situation serves no purpose to ensure his appearance at court or to ensure the safety of the community or an individual. So based on Ms. Stevens' motion, Your Honor, that we outlined and some of the highlights we talked to, we would ask the court to present a reasonable bond and modify the condition to be allowed to have contact with the non-on-duty police officer at the time of December 22nd, 2020. And if the court has any questions, Your Honor, I'd be happy to go through that stuff. I appreciate it. Thank you.
Thank you very much. On behalf of the state,
Thank you, Judge. I'm going to address the request to have Officer Coy have access, or Adam Coy have access to other police officers who are not, parties to this case or witnesses to this case. The state does not object to the court modifying that order. My main concern and our main concern is that of officer witnesses. With respect to bond, Your Honor, and the modification of it, defense counsel has discussed other cases of similar bond or what he believes bond should be. I don't believe there's any other case in Ohio that is similar to this one. Mr. Coy was a Columbus police officer at the time he shot and killed Andre Hill. Mr. Hill posed no threat. Mr. Hill did not provoke Adam Coy, and Mr. Hill did not have a weapon on him at all. And yet he was killed by the defendant. As a matter of fact, Mr. Hill on his person, the only items he had were a pack of cigarettes, a set of car keys, a moderate amount of cash, and a debit card. And that causes concern for the state that Andre Hill was killed and didn't do anything. And so that causes me to question the mindset of Officer Coy at the time, Adam Coy, and the mindset that there was essentially no trigger that was present for him to take this deadly action. Again, that goes to the safety and threat of harm when the court is considering modifying or imposing bond. Additionally, Your Honor, Adam Coy was a firearms instructor. I believe he still is a firearms instructor. That leads me to believe that if he wants guns, he can have access to guns. He can gain access to guns if he wants to. He was arrested as a result of a warrant that was issued on the indictment. And as this court knows, a penalty for murder is a life sentence. And as I said at arraignment, anyone who is facing a life sentence may have that thought that, hey, maybe I shouldn't appear for court, because if I do, I could be locked up for the rest of my life at the end of this case. As a result, Your Honor, the state requests the court to issue a high bond in this case. Thank you.
all right. Anything else on behalf of the defendant?
Briefly, Your Honor, I understand where Mr. Pearson's coming from, and I respect his position, Your Honor. My client's no longer employed by the Columbus Police Department, Your Honor. He was a firearms instructor as part of his duty at the Columbus Police Department, Your Honor. He was also an instructor in the active shooter and reaction scenarios. He would set those up. He has no access to that in any way, shape, or form. The concerns that Mr. Pearson puts forth, Your Honor, his access to potential guns, the court can place orders on there and conditions that would ensure that he not have access to any of the guns, Your Honor. If he was to have access, Your Honor, that in and of itself is another felony charge. Again, Your Honor, the issue here will be whether his subjective belief at the time Mr. Hill was a theft him was reasonable. And that's an issue for trial. And he still has that presumption of innocence, Your Honor. And whether Mr. Hill was armed or not, Graham v. Connor speaks to the fact that an officer can be mistaken if an individual has a weapon or not, as long as that belief was reasonable based on the totality of the circumstances, is the totality of the interactions between the two parties, and a view of it through the lens of a reasonable police officer. And these are the only types of cases, Your Honor, we tell the jury, you can't submit your own personal beliefs in this type of case. You have to actually step into the shoes of a reasonable police officer. And that will be the main issue before this case, Your Honor. Thank you.
Thank you. ties to community is one of the factors. History of not appearing in court, any prior criminal history, whether the person has cases pending before the court now, and the nature of the offense charged, as well as other factors for the court to consider as well. At this time, the court finds that a reasonable bond to ensure the defendant's attendance at trial and for protection of the community is a $1 million bond, appearance surety, $20,000 recognizance bond. If he makes a bond, that would be a reporting bond. Stay away and have no contact with the victim in this case. That is to surrender his passport. No contact with law enforcement officers associated with the case. Is not to possess a firearm as well. The court is basing the bond in large part, obviously, because of the nature of the offense. It's not the worst murder. Obviously, it's not an aggravated murder. And while defense has provided potential arguments and defenses that can be raised at trial, the court is not at this point in time in a position to consider those, or the court is not considering those in determining the appropriateness of the bond in this matter. So, as the state indicated, because of the fact that if convicted, there is a possibility of a life term in prison, the court is imposing a bond that the court believes is a sufficient bond, if posted, to ensure the defendant is present at all proceedings. Is there anything else on behalf of the defendant at this time?
No, Your Honor, thank you again for the professional courtesy of setting up today's hearing.
On behalf of the state?
No, Judge, thank you.
All right, thank you very much, everyone. We are adjourned.